ever watched a courtroom drama, you've probably heard someone shout, "Objection, Your Honor." But in real life, especially in family court, objections aren't just dramatic interruptions. They're critical tools we use to make sure the court hears what should have been heard and filter out what they shouldn't. Today, I'm breaking down the top 5 legal objections in family court, what they mean, when they're used, and how they can directly impact your case. Before we hop in, if you're facing challenges in family court, call a number in description or click the link to schedule your free case evaluation with my team. And if you want more information on objections, I've included a link to an article with more information. Let's start with the most basic and one of the most powerful objections: relevance. In family court, everything should tie back to the core legal issues: custody, support, safety, parenting capacity. If something doesn't help the judge decide one of those issues, it simply doesn't belong. Let's say opposing side brings up your dating life or a years-old argument that has nothing to do with your parenting. Your attorney might respond, "Objection, relevance," because the court doesn't care about gossip. It cares about your children, your rights, and the law. Next, the bane of every law student's existence: hearsay. Hearsay is when someone says, "Well, my daughter told me her teacher said." That's a textbook example. It's a statement made outside of court, repeated inside of court to prove that something is true. Family courts deal with facts, not secondhand stories. And unless a hearsay exception applies, your attorney should stop this in its tracks with objection, hearsay. Because hearsay, no matter how emotional, can't be cross-examined and often isn't reliable. Third on the list, speculation. Let's say your ex testifies, "I think he was planning to take the kids and leave the state." That's not a fact. That's a guess. And guessing doesn't belong in court. When someone tries to testify about someone else's intentions or thoughts, we shut it down with objection, speculation, or objection calls for speculation. Because the only thing that matters is what a witness knows, what a witness has personally experienced, not what they think they know. Fourth, lack of foundation. Before a document, text message, photo, or piece of evidence comes into court, the attorney has to show what it is, where it came from, and that it's authentic. If your ex hands the judge a random screenshot with no explanation, your lawyer should say, "Objection, lacks foundation." Until proper steps are taken to introduce it, that evidence has no place in your case. Finally, number 5. Leading questions. When an attorney questions their own witness, they're supposed to ask open-ended questions, not ones that suggest an answer. If they ask, "You were afraid when he raised your voice, weren't you?" That's leading. It's putting words in the witness's mouth. And that's where we step in with objection leading. Now, while leading questions are not allowed during direct examination, leading is allowed during cross-examination. So you can't guide your own witness through a narrative. Let's recap the top 5 objections in family court. Number 1, relevance. If it doesn't matter to the legal issue, it's out. Number 2, hearsay. No secondhand stories. Number 3, speculation. No guessing. Number 4, lacks foundation. No unverified evidence. And number 5, leading. No feeding your own witness answers. If you found this video entertaining or insightful, like it and subscribe to the channel for more content just like it. My name's Mark Real Jr., the Father's Rights Attorney, and we'll see you guys next time.